City Fuel Corporation of the National Fire.
Mr. Gallagher?
Good morning, Your Honors. I'm Owen Gallagher, and with me is Carol Isley. We represent City Fuel Corporation. This is obviously, when you read the briefs, a very, very narrow insurance issue, but it is an important one. It basically construes the pollution exclusion and the one-word store. What happened here is basically undisputed. My client is one of 900 fuel dealers in Massachusetts that's involved in the retail distribution of fuel oil to consumers. In the ordinary course of business, they load their trucks, and at the end of the day, they park them, and they start the process all over again. If, of course, there was an emergency, they go out during the night if necessary. However, they have a Massachusetts commercial automobile insurance policy, and that comes standard with a complete pollution exclusion. There's absolutely no question that what they distribute qualifies under the policy as a pollutant. So Massachusetts has an endorsement. It's a premium-bearing endorsement. You can pay money for it, and basically any insured who has pollutants is going to buy this endorsement because it gives back the coverage. It gives back the coverage for transporting the pollutants on your vehicle or otherwise in the course of transit.
But isn't the coverage for pollutants that are being transported or otherwise in the course of transit?
Absolutely, Your Honor. But the term otherwise in the course of transit.
Well, does transit mean parked?
Well, we take the position, Your Honor, that it is, that if the vehicle, if you really follow the complete logic of the argument that parked as a single word is storage, and that therefore the exclusion that we'll talk about applies, then you have somebody stopping for lunch. The vehicle is parked, it's unintended.
Well, just hypothetically, let's say I'm a fuel delivery person. I fill my truck up, and I go off on vacation. I leave my truck there. I come back, I deliver some oil, and I go away again on another trip until I empty my truck. Is that in transit?
Well, I would say, Your Honor,
that's your position, isn't it?
That's my position if you take the hypothetical to the, not entirely, Your Honor. It's basically an element of intent. Basically, if you are intending to carry this fuel in the ordinary course of business, it is in transit. I'll give you a hypothetical which is a little longer than that. My vehicles, my clients' vehicles are over the summer, they are not in the ordinary course of business. That is, if my client decided in June that prices were going up and he was going to fill up every one of his trucks and leave them over the course of the summer, I would agree with my brother. His intent is to store that for future use when his season comes back in and he starts going through the process of putting the fuel in transit in the ordinary course of business to deliver it. This would be, again, a question of intent. Basically, if he was taking a month off and he said, I'm not going to empty my trucks, I'm going to store my fuel for the month and come back, that would be his intent. That would be a question of fact. In this case, however, we're talking about very clearly fuel that's being distributed in the ordinary course of business, which we believe would qualify under the in transit.
Is this common? Yeah. Is this a common business practice in the fuel delivery market?
Yes, Your Honor. What happens is that basically you're going to deliver your fuel, and if you finish it, you basically have your workers on a 9 to 5, whatever the schedule is. You don't want to pay overtime. They come back, and if there's some fuel left in the trucks, they're going to leave it in the truck, and they're going to fill it up the next morning, and they're going to use, as Mr. Tenaglia's affidavit says, they have this computerized list, and they know where to go the next day.
Continue making the deliveries. Continue making the deliveries.
Correct, Your Honor.
And I take it that on any given Thursday, they come to the Marshall household, and the Marshall household may need 100 gallons, or 120 gallons, or 20 gallons. They just know that once a month they've got to come and check up, and so they can't calibrate before they get out there how many gallons they're going to use that day, right?
Actually, it's quite interesting, Your Honor. In the affidavit of Mr. Tenaglia, they actually have a fairly sophisticated computer system that basically, not the exact amount, but certainly they know that the Marshall household is in need of oil, that it's reached a level, or should have reached a level based upon the temperature days and the usage that they've calibrated.
Have you looked at any treatises like Couch and the others, Atkinson and so forth?
Well, actually, Your Honor, the major case we rely upon is in our brief, it's the international. First off, Your Honor, this endorsement is unique to Massachusetts. As in many things with regard to Massachusetts.
Thank heaven.
Well, so what we look upon is really just the common sense view of what is this insurance intended to provide.
Well, let me probe that a little bit. I did a little bit of a search of regulations having to do with the storage of explosives and inflammable liquids. And there's a regulation, I don't remember exactly, I don't have it with me, I think it's like 547 CMR 5.08 or something like that. It says that if you leave a tank truck unattended for an hour or more, you have to notify the local chief of police, or fire chief. It doesn't use the word storage, it talks about leaving the truck unattended. What does the word storage mean in this policy? Is there anything?
You have me on that. I'm not familiar with the regulation. We did research regulations, but I'm not familiar with that one off the top of my head. But the intent here is, I think, there's a very good point in my brother's brief. He says this is about tank trucks. It's not about bunkers or storage farms. This particular exclusion, I suggest, is intended to avoid just that. You have, in the insurance industry, everybody writes a policy over here to make sure they cover the auto risk. They write a general liability policy to cover a public liability risk for people walking in a building, etc. They cover environmental impairment insurance for types of pollution. What this exclusion is intended, in my opinion, is to avoid someone being an unscrupulous entrepreneur and saying, you know, I can make a lot of money. I can buy auto insurance very cheaply, and I can use this trucks to store fuel. For example, it's the same. You have to look at the context of the exclusion.
But what do you mean store fuel?
Well, for example, you have a business where you have, again, this regulation. You have very detailed regulations relating to how you have to store a particular type of fuel or a particular chemical, and you have to get environmental impairment insurance. But you get
But then the cost of your truck is for naught, because the truck, I assume, is one of your big capital costs in your business, buying a truck.
Well,
and if you're going to buy 10 trucks and use them just for storage, you're wasting all your investment in the trucks.
But it's really the issue, Your Honor, isn't it? Because obviously the person is going to invest in some very old, very decrepit trucks.
You may or may not. You may find that there's a huge profit to be made in storage, but you don't have a hope of getting permission in, the town where you live, or, even though it's an industrial area, of getting permission to do that. They're not going to let that. I mean, there are all kinds of costs associated with operating a storage business.
You mean fixed storage?
Correct, Your Honor. That basically
just parking the trucks.
You park at the truck and you bring in the hoses, and you use that in lieu of some other type of storage device that would cost you a lot of money to insure.
And you're talking about not using the trucks for purposes of delivering fuel.
Perhaps I can give a better example. If you look at the context of the exclusion, the exact words that are used on it, and there's 4 verbs that are used: stored, disposed of, treated, or processed. For example, treated. It's very expensive to buy insurance for insect exterminators. They come out, they mix together chemicals. They can be very dangerous when they mix them. They have to buy insurance because they come to your house and they do it. Obviously, this exclusion, treating it, prevents them from saying, oh, if we bring it in our truck and we set it up so we can process or treat this material in the truck, we'll have insurance, because if it blows up or it leaks out or we have some adverse reaction, we're covered. That's what I believe honestly, this is what this is intended to do. If they wanted to say you can't park the vehicle, there's be no coverage, that's a perfectly valid word. This will not cover you when you're parked if the vehicle's unattended.
I take it your client doesn't view his business as one of storage, but simply delivery.
That's exactly what he does. Absolutely.
Picks it up at point A, delivers to point B, sometimes B, C, D, E, E, N, and sometimes the truck is not physically moving.
During the heating season.
I was going to say, I don't know how you break out this word storage, but unless you're actually pumping the fuel in a direct pipeline from a source to the user, to the ultimate user, in effect, you're always storing it in the truck until you deliver it to the next house. Well, there's an element of storage in the delivery system.
In that case, Your Honor, I would say we're really talking about something that's ambiguous, because you can always say that something is stored, but the issue here, as far as I see it, is this vehicle is designed to transport equipment, transport a particular substance.
But we have a slightly, I mean, it's on the one hand, you have the company saying, we're not insuring storage, right? And,
Correct.
And then you say, okay, so now I'm going to buy something that does, I mean, we're not doing pollutants. Now I'm going to buy something that will provide me insurance for what I do, correct? So I buy it, and it says transport or in the course of transit. Well, I don't even know what in the course of transit is, but it seemed to me that at least if I'm not transiting, in the course of transit means I'm stopping, right? I'm stopping. And sometimes I stop for 10 minutes.
Correct.
Sometimes I stop for 2 hours over lunch. Sometimes I stop overnight. I'm in the course of transiting from one customer to the other.
Right.
I'm not storing.
Correct. I mean, if that provision would not be necessary in the endorsement that was bought, if in fact this was limited to the actual transport.
Of course, this being an exclusion, it's got to be construed strictly in your favor. After all, you're paying money for this thing.
Correct.
For this protection, and all of a sudden have it pop up and bite you because you had it in the vehicles overnight is...
It's not entirely clear to me, Mr. Gallagher, that if I'm getting coverage for polluting, okay, and I'm driving an oil truck, how fast do these trucks go?
They're all local delivery, Your Honor.
Okay, so maybe they go 30 miles an hour. I don't know. That if there's a leakage, if I'm polluting, I'm not polluting an awful lot as I may be polluting some. But I am polluting when I'm stopped dead, right? I'm stopped dead, and so it can't. I'm essentially agreeing with your position, but for another reason, which I can't understand how you can pollute in the transit business, in the oil delivery business, unless you are stopped, because that's when the stuff is going to leak out.
In fairness, I mean, to the general major risk for obviously for these tanker trucks is a collision, and then you have a discharge, which can be fairly major.
Would you be covered if, as happens every so often, they pump the fuel down the wrong?
That would be, actually that's the loading and unloading provision which is in there.
That's okay?
That would be, I believe we would agree that would be covered.
Okay.
One of the issues we have with this type of the interpretation by the insurance company is that, as a practical matter, keep in mind, this is not just a case about 900 companies doing fuel trucks. This endorsement applies to every single transporter in the Commonwealth. So it's not just fuel trucks. It can be anybody carrying any hazardous waste which possibly could stop. You have then this anomalous situation in which if you're parked overnight, you have no coverage. What do? You either have to buy environmental impairment insurance for this limited risk, which is very expensive and adds cost, or every night you unload, every night you go back.
No, let me just take another one. You're parked, right? You're parked. And so, you just said, well, you know, the biggest risk is collision. So you're parked perfectly legally. Maybe you parked over the weekend. And some operator of some other automobile or truck smashes into you. And the insurance company says that you were stolen. You're not covered. I mean,
Correct.
I mean, I'm essentially asking, I'll ask the defense counsel to answer that. But essentially,
well, hopefully, if you were parked, you'd also have no liability. But you're correct. That would, if this exclusion was there and you claimed defense and indemnity, you would then be subject to this interpretation, which is there. I'll just finish up. The other issue I just wanted to raise was the MCS-90 endorsement. The gravamen in the argument that we have here is not as my brother says, that this is something that is paid upon a judgment. The issue here is this is part of the insurance contract. And one of the things that my client bought was a series of services which were very important. When this insurance company walked away, they walked away with an agreement that they would investigate and they would settle. As my brother points out, they may well have the right to collect it back. But these were very valuable services. In other words, my client had to go out and pay the full boot, when in fact it could have been that the insurance company could have used its expertise that he bought to settle this case.
Is there an obligation to defend against the administrative order?
There would be, Your Honor. If against the administrative order, the MCS 90 endorsement talks about a judgment, and we write it in detail in our brief about this issue. And I see my time's up, so.
Well, but that's as to payment, isn't it? But if you get an administrative order and you want to litigate it, is the insurance company obligated to represent you in that administrative litigation?
If there was coverage and there was a duty to defend, I believe they would, Your Honor. But again, it gets into this issue of the policy interpretation, where the endorsement we bought, which they say doesn't apply, would in fact cover that. But you then get into this circular argument. Our position is that because of this MCS 90 endorsement, which is part of the policy, they would have been obligated to perform the other obligation of the policy, which also would have been of great benefit to my client. Thank you very much for your attention.
Thank you, Mr. Gallagher. Mr. Aylward.
Chief Justice Marshall, members of the court. Let me start where my brother ended. There is no duty to defend under the MCS 90 endorsement. All that it provides is that even if a loss isn't covered under the policy, the insurer will pay some third party that's injured by pollution and is thereafter entitled to be reimbursed. It's a statutory endorsement. It doesn't create a duty to defend or the penumbra of obligations to investigate or handle claims that would arise under the policy itself. There are two basic issues of policy interpretation that this case presents. My brother concedes that the exclusion in the main body of the policy absolutely defeats coverage. So the only issue before the court is the scope of an endorsement that adds certain types of pollution coverage. And that endorsement only applies if the pollutants are being transported in the course of transit. So the threshold question is not an exclusion as to which my client would have had the burden of proof or as to which questions of ambiguity would apply. The threshold question is whether if a fuel spill occurs while a tanker truck is parked overnight at a terminal.
Now, wait a minute. Why overnight at a terminal as opposed to, I mean,
We concede if a truck was stop and go, if somebody stopped for coffee break, if they stopped at the side of the road for a cigarette, that's in transit. If there's a progression.
But by your interpretation, as I understand it, Mr. Aylward, you would require these companies to operate 24 hours a day, because it cannot be the case that what the policy contemplates is that at the end of the day they have to go back to the place in which they purchase fuel and pump it back into the storage tank. And we know, even though they have relatively sophisticated means of knowing how much Marshall versus anybody else uses, you can't know to a certainty, because maybe my mother-in-law was visiting and I had to put the temperature up, and so I suddenly used twice as much.
We don't dispute that, Your Honor. But
well, what would you have the
that's the
companies
natural
do?
consequence, because
What would you have the companies do with the oil that is left over at the end of the day to avoid, quote, unquote, storing it in the truck?
But they do store it in the truck.
No, I said, what would you have them do with the excess fuel at the end of the day?
I don't think there's any problem with leaving it in the truck. Obviously, you can't know with such precision.
Well, but then it's stored on the.
It's not covered. Your argument is it's not covered. You have to buy another ride.
I would expect under that circumstance that a loss that occurs at a fuel oil terminal would either be covered under the policy insuring the fuel oil terminal, or as in this case, where it's a third party using the fuel oil terminal, that whatever contractual arrangements they have to leave their trucks there overnight and use the terminal would extend to losses involving spills at the terminal.
But this really has nothing to do with where. I mean, say, for example, you have a, two-truck operator, and the two-truck operator stores the two trucks for no cost in his next-door neighbor's backyard because his next-door neighbor doesn't mind. Just a nice neighbor. you would have the same issue. And one of the things that concerned me about the Meinster decision, and I don't know what the status of that is now, that you relied on, is that this was vandalism. You can have vandalism when the car is parked, I mean, the truck is parked in the middle of the day. In other words, what you have to explain to me is in the course of transit as opposed to transit. And you've got transit or in the course of transit. So if it's only transit...
Your Honor, I would refer this court back to the Whitehall decision that was decided, where, and I quote, "The natural meaning of the words transit and transportation is that it shall be in the course of movement from one place to another."
Yeah, but that means that if I am parked for lunch and the vandals come and, vandalize the truck because I parked in, downtown someplace, that you say not covered.
No, not at all. Clearly, it's being moved from one place to another. The mere fact that it stopped for a short period of time while you're having lunch.
It doesn't say short period of time. What I'm saying is the logical consequence of your argument is that they have to keep going 24 hours a day, or they have to go back to the cellar of the fuel and pump the fuel back again, and that doesn't make any sense at all.
Your Honor, one of the basic rules that this court has evolved for interpreting insurance policies is that a word is presumed to have some meaning, or it wouldn't be there. There has to be some meaning for in transit or transportation, or the policy is meaningless.
It's only meaningless if you take it in contradistinction to what's excluded. And I agree that so that you say it's not covering storage. But there's nothing that suggests to me that this was the parking a truck for 10 minutes, an hour, 5 hours, or 12 hours.
Except that what's being insured here is a commercial vehicle,
right,
the purpose of which is to deliver fuel. It makes perfect sense for an automobile insurer to cover the risk of those fuel deliveries. But those fuel deliveries are done at the end of the day. At that point, the insurer legitimately is not insuring certain risks associated with the non-transportation function
Then
of
your
the vehicle.
position has to be that if you're parked for lunch between stops, let's just do the lunch. You park between lunch, and there's a leak, either for vandalism or because there's some corrosion that the company hasn't seen. That's not covered.
I disagree, Your Honor. Respectfully, that's what in transit means. As this court ruled in Whitehall, there is motion from one place to another. There may be a temporary cessation of movement, but it's still in transit. It's going there.
And so
when this vehicle was parked overnight, it wasn't going anywhere.
I am between customer Marshall and customer Aylwood. I actually had hoped to get to customer Aylwood at 4:30 in the afternoon, but because there was a massive traffic jam on 93, I only got as far as Marshall, so Aylwood is my first one up the next morning.
Storage. That's storage. You
Your
go
Honor,
back and you park it overnight.
If you go back to the terminal, stop, and start over again at the next day, Justice Greene, that's storage.
That's what I said.
If I'm driving...
Did I say that? That's what I said.
I'm sorry, Your Honor.
It's sometimes hard to know that a justice is actually trying to find an
agreeing with
argument to
you.
support you.
The Whitehall case that you cite, of course, relies on a very interesting case written by Chief Justice Rugg back in 1921, in which he has an extensive conversation about the meaning of transportation and transit in the context of shipping goods. And it goes all over the place to talk about how broadly the term has now become. And this is 80 years ago. But there's an interesting quote from another case, in this case. It says that transportation from one point to another remains continuous so long as intent remains unchanged, no matter what stoppages or transshipments intervene.
Exactly.
So you pick up oil from point A with your intention to deliver it to a variety of other points. You get half the deliveries done. You then stop the vehicle and you pick up the deliveries the next day. The intention to deliver has never changed. And there may be intervening points at which the truck is not moving, that the goods are stored on the pier ready to be picked up by someone else or stored in a lot ready to be delivered the next day. It's still transportation. It's part of the transit of the goods.
I agree, Your Honor. In that circumstance where you've got this one long voyage with points in between, it's in transit. if the vehicle goes from Boston to Newton to Worcester to Springfield and then comes back, even though it stops on the way, the vehicle is in transit.
But if it goes from Boston to Worcester, if it goes to Boston to Worcester to Springfield, half delivered, spends the night in a parking lot in Springfield, and then comes back and delivers down the rest of the route back to Boston, why isn't that the same as here? Just because the parking lot is local rather than far away?
Because there's one, it's in transit. There is an extended voyage contemplated. Here, if they're correct that every time at night they end the day's deliveries and start over the next day, it's still in transit, then that vehicle is always in transit. And those words are meaningless.
Well, it's always in transit unless it's not, unless it's in storage. In
But
other
under
words,
this theory, until a car is
and doesn't
taken-
that have to do with intention?
And under that
And
analysis,
business practices?
well, unless the car is taken off the road and the license removed, it must therefore be in transit.
No, if it was, say it was just stopped and they decided not to use that vehicle anymore, then it's not in transit, or not to use it for 2 weeks. That's a different story than if it's just being used daily and with a residual amount in there overnight.
But that wouldn't be their argument. Their argument would be any cessation, it's still in transit. They're not dependent on whether
I'm
it's for
not
6
sure I
hours or
read their
24
argument
hours or
that
6
way.
days.
I'm not sure I read their argument that broadly.
Sometimes these oil...
I love the way the trial judge, and I give him absolute, full credit, and, when in a state of steadiness. I mean, it's just a wonderful phrase. When in a state of steadiness, when the vehicle, such as when a vehicle is parked overnight. But again, by Justice Cordy's hypothetical, you're doing a long route, and so you know that you're only going to be able to get half of it done on Thursday, and then you're going to be out in Springfield. And
You're right. I'd go back to the basic insuring language, not the exclusion, the insuring language in the endorsement, being transported or otherwise in the course of transit. When I came in today on the Green Line, I was being transported. The D-Line train was in transit from Newton to Boston.
And if we
Tonight it goes back to the Riverside Terminal, and it's no longer in transit. It's sitting there in a depot. That's exactly what we have with this fuel oil. Tomorrow morning it'll start all over again, but it can't be in transit when it's just sitting there in a state of steadiness. It is a lovely mellifluous term.
On cold nights, a person could run out of home heating oil and call in on an emergency basis at midnight and get a delivery. If the oil truck, if the oil distribution company were to anticipate this and have a full truck of oil available on cold nights, the driver came back at 5 o'clock at the end of the day, filled it up, expecting to be called out in the middle of the night. If it were parked there, waiting for a call from 5 at night until midnight, would you say that was in storage?
Yes, I would. For the same reason that it's not a function of what time of day or night it is. It's the function that it's being stored for future use. In that event, there's a possibility that there will be a need at 2 in the morning in Roxbury, and at that point the tanker truck will go off and make a delivery. But it's being stored for that future use. Until it's actually in transit, it's being stored.
But what that says, and again, I don't want to belabor it, Mr. Aylward, but what that says is there is no way that you can get coverage, because you can't store, right, that's excluded, and you can't get it in transit if you are in the transportation business, unless you go back to the supplier and tank the oil back into the supplier's tank. And that, it appears to me, is not the way that these oil delivery companies are functioning.
But, Your Honor, there are many situations where involving warehouses or bailments where there are contractual undertakings and relationships and additional insurance being added to one policy or another that cover those various sort of eventualities.
I would find your argument more persuasive if you said to me, transit means transit. What this was really designed to do was for collisions and the kind of accidents that happen while these trucks are moving along. It was not designed to cover the lunch hour stop. It was not designed to cover the overnight stop in Springfield. It was not designed to cover when that truck was in a state of steadiness at any moment. It was only when the wheels were turning around and it was moving. That's what this covers. right? And you can have automobile policies like that. It would be that would be a little unusual construct.
Your Honor, we could make that argument, but I think that's extreme. And we would get into splitting hairs as to whether if the vehicle had stopped or the brakes were put on and then it was moving again, or I think a more practical analysis of the policy is to distinguish between losses that occur while it's in transit, while things are happening in the capacity as a transportation delivery vehicle, and things that happen after it's in a state of steadiness, where things have stopped, where it's there waiting overnight until things start again the next day.
Because that's where, I'm agreeing with you here, that's where the types of accidents and problems that you don't want to insure could occur, such as what happened here, got cold and the pump or whatever it was exploded, or vandals get in and, open it up, and those are the kinds of things you don't want to insure against.
And that involve a different kind of risk that ought to be insured under.
Well, correct. So that's what the exclusion is there for.
Mr. Airwood, I understand from Mr. Gallagher that this was, I don't think he used the word unique, but unusual to Massachusetts. But obviously the Maryland policy was close. I mean, that's a different way of saying, are there similar types of policies around the country, or is it just Massachusetts and Maryland that have these?
This is not, there's nothing in the record saying this is unique to Massachusetts.
Well, so then to go back to Justice
This is
Davis.
quite common around the country, and frankly, I think it's indicative that this is the first reported case, other than Meinzer 20 years ago, where this issue has been raised. I think it indicates that the law or the relations of the parties are fairly decided.
And is there anything in the two major treatises, or however many treatises there now are, on insurance coverage, what this means?
No, because there's no case law construing it.
I mean,
yes, we've looked in Couch and Appleman, and there's nothing there.
So I take it then that what the insured purchased here is a policy that covers collisions, spills that result from a collision. That's the primary anticipated.
There's a little more than that. I mean, the endorsement has three parts to it. It includes losses that occur while the oil is being unloaded and the tank is overfilled, or it goes down the wrong pipe, or things like that. But it's functionally covering risks that involve the delivery or transportation of the oil.
is it possible that the reason why this hasn't arisen is not because there have been lots of leakages overnight by vandalism or by accident, but because that is such a rare occurrence, because in fact, these not involved in collisions, that's the major risk, but the chances of an oil truck, as I say, leaking sufficient that it causes a significant amount of pollution is just very rare.
It's actually not that rare, Your Honor. So, no, I don't think that's the reason for it. Thank you, Your Honor.
Thank you, Mr.
Thank you for the report.